holds a valid passport which he is prepared to surrender. That fact was not disputed by the state, that he has a passport and it's available for surrender. He further indicated his qualifications as well as his address in Ondangwa, where he resides. That fact remains undisputed and uncontested. He then took the court into his confidence and indicated that he only has Namibian residency, no foreign residencies in other countries, no living relatives outside of Namibia, no immovable assets in Namibia, and he's not married, has a daughter. Those factors still remain uncontested. The fact that he had no antisocial behavior, no criminal cases pending before any court in the country, as well as no previous convictions, also remains uncontested before this honorable court. His residence that he has also constructing at Onamulunga village, which solidifies his roots in Namibia, also remains uncontested in Namibia, in this honorable court. As indicated, Your Worship, there is very little that Ms. Inambao placed, or the investigating officer placed or contested in dispute in respect of the application of the 7th applicant for bail. I will point out what those issues are very soon in my address, because they are immaterial in any event to the question of bail. We submit they are material perhaps if we get to trial, but in this proceedings, those issues that he raised were immaterial and are immaterial. The issue of the release of the co-accused on bail is an important issue that the court must look at. Because you will recall that I placed to the witness in cross-examination the charges of a co-accused that was granted on bail, granted bail in the amount of 50,000 in this matter, and the investigating officer confirmed those charges are serious. However, as soon as I made it known to him whose charges those were, he protested. It cannot be that charges that are similar are alleged to be of the same, from the same facts and conspiracy, are serious only in respect of my client, but they are not in respect of another person if they are based and premised on the same facts. Page. Your Worship, there was a judgment that you were referred to on that issue. That would be the Amushelelo judgment. Amushelelo versus the state, at paragraph 34 thereof. Where I believe it was Justice Liebenberg who made a remark that is important in respect of the granting of bail of a co-accused in the same matter. And this is what the court said. Reference was earlier made to the 6 co-accused who were released on warning, despite facing the same charges as the appellant. There is, and this is important, Your Worship, there is nothing in the record that remotely explains or justifies the inconsistent handling by the police of the appellant's case opposed to that of those co-accused. The mere fact that the co-accused were released on police warning rather suggests that the offences charged were regarded to be of a less serious nature. For some reason, this did not apply to the appellants. While the true reasons were not explored, the only reasonable conclusion to reach is that the disparity was because both the appellants were already out on bail on other cases. But here we are not dealing with an accused person or co-accused who is granted bail by police. We are dealing with a co-accused who is granted bail by this honorable court, who exercised the discretion when the state indicated to the court that there is no longer an objection. That is why we invite the court to have regard to the issue of the absence of objection on the same charges, in the same case, premised on the same facts, when the court decides this matter. Your Worship, the next authority I wish to refer the court to is the matter of Tebuho, T-E-B-U-H-O versus the state. That is a January 2022 decision where the High Court, sitting as an appeal court, remarked and held as follows. They actually just referred to the Amushelolo decision and said that we must have regard to the other co-accused and then treat all accused persons equally. In that Tebuho matter, the High Court also said that considering the testimony and submissions that abscondment is remote and that he does not know who the state witnesses are and thus cannot interfere with witnesses, suitable conditions may be imposed. The court further said the appellant is a first offender, has steady income, and testified to be without any ties outside of Namibia. He does not have any relatives out of Namibia and is prepared to surrender his travel document to the investigating officer. He testified to his willingness to abide by any conditions the court may deem necessary. In these circumstances, it is in the interest of administration of justice, the public interest, and the accused's right to liberty to release the appellant on bail with suitable bail conditions. I submit that applicant number 7's case and this Tebuho matter are identical. They are on all fours. The facts are similar, or the considerations that the court took into account are also present in this matter, and therefore invite the court to make the decision in line with what the High Court eventually decided. Your Worship, I will now briefly have regard to the grounds of opposition proper and start with the risk of abscondment and seriousness of the state's case. I've submitted to the court that the issue of risk of abscondment and seriousness of the state's case are interlinked, not because one wants to determine the guilt of the accused person in bail proceedings, but because one wants to determine if there is an incentive or a likely incentive for the accused person to abscond once granted bail. Your Worship, because bail is premised on a constitutional right to liberty, and the Constitution being our supreme law, in our jurisdiction, and again I refer to Balder versus the state, where the court was faced with a British national, not a Namibian citizen, and this is what the court said. Mobility in the sense of having the financial means to escape is merely but one of the factors to be weighed with the other relevant factors. The court also confirmed the principle from Shaduka versus the state that being a person with substantial means does not automatically make such person a flight risk. As another consideration will be that as a wealthy person would not, without serious consideration, opt to lose his or her wealth in the face of hardship as a fugitive. The court also held further in that matter that the fact that an applicant, and I emphasize, is a foreign passport holder alone, that factor alone does not automatically mean that such person is not entitled to bail in any circumstances. So it means the court, when exercising the discretion, must have regard to those principles and apply them to the facts, but keep in mind that our court, the High Court, has gone as far as upholding an appeal against bail that was refused to a foreign national. In this instance, in the present case, the applicant is a Namibian national. He is prepared to provide his passport. He is prepared to adhere to bail conditions that might seriously limit his travel within the jurisdiction of the country and or of this court. And more importantly, and that must be looked at, is the conduct of the accused person. Once contacted by the ACC, he went to meet the ACC in Ondangwa, where he was arrested, and then he was transported to Windhoek, where he remains in custody. He did not at any point attempt to escape all the way from Ondangwa to Windhoek, nor did he fail to report himself to the ACC. Therefore, this ground of objection, even if one has regard to what the investigator said, that he did not know he could be arrested, that's why he went to meet the ACC. He also did not know a lot of things, but the important factor is there is no evidence that he tried to abscond. This ground should be dismissed. It has got no merit whatsoever. The next grounds that we must look at is the high risk that the accused will interfere in ongoing investigations, and that additional suspects still need to be arrested. And if Mr. Nandaro is released, he will interfere in the investigations. Justice Liebenberg, in the matter of Shidhu versus the state, it's a 2017 decision of the High Court, reminded us that in deciding the risk of interference, Your Worship, with state witnesses or the investigation itself, the proper approach is to ask whether it is likely that the appellant will, not may, interfere. So the proper approach is to ask whether the appellant or this applicant will interfere, not he may, because there's a lot of things he might do. He might drink water tonight as well. But the court must be satisfied that he will interfere. In the absence of actual interference in the past, Justice Liebenberg held, well-grounded fears of interference, those well-grounded fear of interference might suffice to refuse bail. We submit that in this present matter, there is no evidence of actual interference on the part of Mr. Nandaro, nor is there any evidence of well-grounded fears. When the investigating officer was asked about why he fears Mr. Nandaro might interfere, he attempted to establish this point by stating belatedly that there was information of involvement with a suspect, an unnamed suspect, a suspect yet to be arrested. But this was before Mr. Nandaro's arrest. And when pressed in cross-examination, because the impression he was trying to create was an adverse impression, when pressed in cross-examination, the investigating officer on that issue considered that the information that he supposedly received relates, one, to before Mr. Nandaro was arrested, And secondly, he himself kept emphasizing that the applicant was not aware he would be arrested. And therefore, he was at liberty to speak with anyone. So if the court relies on Mr. Nandawa's testimony, the investigating officer's testimony, that the applicant number 7 was not aware he should be arrested, he would be arrested, it should also then follow that him not being aware he would be arrested, he obviously would not know or is not precluded to speak to any member of the public based simply on Mr. Inambao's testimony or version. Another issue that the court must have regard to is the investigations and where they are. Mr. Investigating Officer testified that these investigations are at an advanced stage. This is important for the issue of what a person can actually interfere with. Bank statements have been obtained. Bank statements are in the control of banking institutions. Mr. Nandago has no access to the banking institutions, nor does he have access to the police docket to go in and erase transactions from bank statements. So it's important to also then look at what Mr. Nandago alleges in respect of the investigation. He alleged in his founding affidavit that this specific investigation, and it was confirmed by the investigating officer, that this specific investigation is premised predominantly on statements, documents, and that witness statements have already been obtained. So there's very little that an accused person can interfere with at such an advanced stage of the investigation, if at all such a ground exists or such a fear exists. That allegation that was made in the affidavit remains uncontested. It has not been disputed that that is what the investigation is premised on. It's on that basis that we submit that there is no evidence of firstly interference, nor are the fears of the state well founded. The court then must lean towards granting bail. I'll then make a few remarks that are important for the court to have in mind when it determines Mr. Nandago's application for bail. The investigating officer was unable to provide the court with an approximate time for completion of the investigation. Even when pressed or pointed out to him that it is important he appraises the court, he failed to do so. I went as far as reading out the months of the year to get him to give some clarity to this court, but he was reluctant. I'm not going to venture any speculation as to why, but the issue is the finalization of investigations is important for the court to know that are these people to be held in custody, Mr. Nandago to be held in custody until the finalization of investigation or until the finalization of the trial. He did concede, however, and this is also important, he considered that the Prosecutor General's decision would be required in this matter and that the matter is likely to be tried in the High Court of Namibia. In light of those concessions, the investigating officer still and unreasonably failed to explain or to indicate up to when the objection is. So is the objection only until the investigation is finalized? Then they will no longer object to bail? Or is the objection until the trial is finalized one day, an indefinite date that none of us are able to state today, because no trial date has been set yet, no charges have been put. The charges are likely to be amended before a decision is made by the Prosecutor General's decision, Prosecutor General, and then the matter is transferred to the High Court. So those are factors that this court will have to hold against the state, because that should have supported its objection, but they failed to deal with those aspects adequately in evidence. And no, Your Worship, it cannot be done in submissions. It cannot be done from in submissions. Not such an important issue, even though bail proceedings are easygoing and statements from the bar are permitted. One must look at the contents and the importance of it. Another issue is that during cross-examination, the investigating officer considered a very important point in the fuel supply agreement between NAMCOR Trading and Distribution and Petroleum, Erongo Petroleum CC, pertaining to the quantity of fuel, because the whole time his testimony was that there is a credit limit of 3 million for Erongo Petroleum CC. Until he was pressed to go to the document, he saw that that is 3 million per month. And it's not a credit limit. It's an agreed quantity of fuel to be supplied. 400,000 liters, the equivalent of 3 million per month. If you calculate and you multiply that by 12 months, the state's case will fall completely flat. If you calculate the 3 million per month, 4,000 liters per month. That's an important qualification that was absent until it was put to him in cross-examination. And this allegation or this concession actually puts to rest the issue of the purported credit limit and supply of fuel to Erongo Petroleum Limited in excess of a purported credit limit, which in any event is not a criminal offense. It then puts completely to bed and to end the charges against the seventh applicant, particularly charges 61 and 62 that speak to supply of fuel in excess of a credit limit and fraudulent misrepresentation. Charge 61 alleges that Mr. Nandago misrepresented to NAMCOR. There's no mention of who at NAMCOR. It alleges that he misrepresented that fuel was being paid for by Erongo Petroleum when it was supplied with that fuel. The investigating officer considered that Erongo Petroleum in fact was making payments to NAMCOR. And in the affidavit by Mr. Nandago, I painstakingly read through all the payments amounting to almost 100 million. That issue was simply not engaged with. I went to the date, I read out the amount. The investigating officer did nothing. That evidence remained uncontested. The payments per day for that period remain uncontested. The witness then testified that he found contradicting documents at BIPA, contradicting insofar as the membership of Erongo Petroleum as to whether Mr. Nandago at the material period being, Your Worship, December 2022 to May 2023. I repeat, December 2022 to May 2023. But he chose to rely on a document of 2020 as opposed to a document, the founding statement, plus an amended founding statement, the last date of which is October 2023, which lists 2 other members as only ceasing to be members on that day, and therefore Mr. Nandago becoming 100% members' interest holder of Erongo. So he persisted, chose and elected one document in his docket which supported the narrative that he wanted to pursue while he was in possession, or the ACC was in possession of a document that directly corroborated the applicant's case.
Yes, Counsel, I'm going to stop you there. We have gone to this point because, as we have agreed, I was under the impression we were going to finish, but it's apparent and clear we are not, and we cannot finish. Yes. So I'm inclined to stand the matter, and as I have indicated, that availability becomes an issue. Yes. The court is engaged.
Your Worship, may I? I know
Yes,
she
you can,
was too
yes,
busy.
you can approach your colleague. Or do you want?
Yes, I just wanted to play something on record because seeing that there was also a suggestion that the other bail application proceeds tomorrow for the other applicants who are not before this court. Okay. I was just hoping that perhaps we would finish, but it looks like we won't finish. But I've just got an indication from Ms. Gebhardt that she will only have 5 minutes, then she will finish. But then that begs the question as to when, then I'll be given an opportunity to make my submissions.
Yes,
then.
because that is, yeah.
Yes. Is the court not available tomorrow?
No, the court has already indicated I have another bail application, and we have agreed with counsels. There are 3 accused or applicants and 3 defense, 3 counsels. We have agreed because for the time being we have proceeded with this one. That matter was on starting at 1400 hours, but we have agreed to start earlier because also I was under the impression that we were, as we have agreed that by Tuesday, actually the agreement was that by Tuesday we should be finished. So without knowing that, because I've already agreed with the other councils, that will start earlier on the other bail application. Yes.
Your Worship,
Can we?
Yes.
Yes.
Your Worship, I would not want to dictate to the court, but I was just hoping if tomorrow is okay, if we do it at 9, so that at least we can make our submissions, or at least for me, because it looks like I'm the only one remaining to make my submissions, and then the court can make a judgment later, because it will appear that I might be engaged in the other matter that is set to start tomorrow. That is the unfortunate part.
Yes. Can we?
Maybe we can adjourn and we
Can just adjourn?
Yeah.
The court will briefly adjourn.